Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today because you have a case in this court. The case that you have is a criminal case. Criminal cases are divided into felonies or misdemeanors. In this court, we have misdemeanor. We handle misdemeanor cases. Therefore, your case is the misdemeanor case. Felony cases, if you had a felony, they're divided into 5 categories. You have the capital murder, first degree felony, second degree felony, third degree felony, and state jail felony. Your felony cases are normally referred to as your more serious type offenses. And when I use the word serious, what I'm talking about is the facts, circumstances of the case, as well as the punishment that a person can receive if they are convicted of a felony offense. If you're convicted of a felony offense, for example, if you are convicted of a state jail felony, which is the lowest felony, the range of punishment is minimum 6 months to a maximum of 2 years in a state jail and a fine up to $10,000. If you're convicted of a third degree felony, range of punishment minimum 2 years to a maximum of 10 years in a state penitentiary, a fine up to $10,000. If you're convicted of a second degree felony, the range of punishment is the minimum 2 years in the state penitentiary to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine up to $10,000. Now, if you're convicted of the highest felony, which is a capital murder, the range of punishment is life without parole in the state penitentiary and or death by lethal injection. You don't have to worry about that because your case is a misdemeanor case. Misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that the facts, circumstances, and the range of punishment is not as serious as a felony offense. Misdemeanor offenses are divided into 3 categories. And we'll start at the top. You have the Class A misdemeanor, Class B misdemeanor, and then we go down to the Class C misdemeanor. Now, the Class C misdemeanor offenses are those offenses that normally start in the JP court or the municipal court. And if those cases are appealed, then they come up to this court. Now, the range of punishment will stay the same. And so the range of punishment for a Class C misdemeanor is by fine only. So you only could get a fine. Normally, the fine is up to $500. Now, with the Class C misdemeanor, for example, it will be a case like not wearing your seatbelt, speeding, and a whole host of other offenses. If you are convicted of a Class B misdemeanor, now your Class B misdemeanor range of punishment, the minimum of 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine from $0 to $2,000, or you can be given both such confinement and fine. If you're convicted of a Class A misdemeanor, this is our highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may be eligible for one of 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated, we normally refer to as deferred probation. What that basically means is that you will not have a conviction on your record. And if you successfully complete the probation, you will not have a conviction. The case will be dismissed, and you may qualify for what we call a non-disclosure. Non-disclosure basically means that we cannot disclose the fact that you were on deferred probation to the general public. Now, most state agencies will be able to get a copy or be able to get a copy of the fact that you were on deferred probation. Now, the other type of probation is adjudicated is different from unadjudicated. Adjudicated probation, we normally refer to as regular probation. And with that type of probation, you do have a conviction on your record. However, there's something that is called judicial clemency, where the court can set aside the conviction. And in order for that to happen, you have to first complete the probation. They cannot have any more time left on your probation. And you have to be discharged off the probation. And if those things happen, then the court can set aside the conviction, and it cannot be used against you in the future. However, if you get a subsequent conviction, another conviction later on, then this case that you receive the judicial clemency on can be brought back up. It could be resurrected, revived, and brought back up to be used against you. And if you try to get a license with CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend the license that you have. Now, as a defendant in a criminal case, you have rights. Now, one of the rights, the first right that we're going to talk about, is your right to have an attorney. And that the information that is on the clipboard, I'm going to go over that information with you. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And basically, that document states, as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Representing yourself means that you'll be giving up your right to have an attorney to represent you. You'll be waiving your right to an attorney, and then you'll be representing yourself. Those are your three options regarding your right to have an attorney. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means that you will be given another court date to give you time to hire an attorney. If you want an attorney and do not have the money to hire an attorney, you will need to fill out a financial questionnaire. Now, that financial questionnaire is also attached to that clipboard. The financial questionnaire is titled Jefferson County Affidavit of Indigence. So you would need to fill out that financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, you may not, if you want to represent yourself, that is, you want to waive your right to an attorney and represent yourself. Now, if you want to do that, you can't talk to the prosecutor, the assistant criminal district attorney, about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver should be the second page on that clipboard, and it's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, only those individuals who will be waiving their right to have an attorney and desiring to represent themselves, they will have to read and sign this document. I'm going to go over this document with you also in a few minutes. Now, the next statement on judge's explanation of rights to defendants without attorney says, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, that is, if you decide you want to waive your right to have an attorney and represent yourself, you may change your mind at any time and may request counsel from the court. Now, at the bottom of that document, in bold letters, it states defendant's choice. And it states mark initials next to only one choice. And below that statement, there are 5 lines with statements next to them. If you want to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, August 22nd of 2023. Now, for those of you who will be waiving your right to an attorney and desiring to represent yourself, you will have to read and sign the next page that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And I'm going to go over this document, which and it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. That is, nobody's forcing me to do it, and I know what I'm doing because I've read this document. Furthermore, I have been advised this 22nd day of August of 2023 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge, understanding my right to have counsel appointed to me free of charge. If I'm not financially able to employ counsel, I wish to waive or give up that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, August 22nd of 2022. One other right that you have is a right to have a trial by jury. When those young people are sitting in that area of the courtroom, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors on your case, and they will listen to all of the evidence that is presented, to all of the arguments, and then they will retire and deliberate. And after they deliberate, they will decide to find you not guilty or guilty. You have a right to waive or give up your right to have a trial by jury. What that simply means is you have a right not to have a trial by jury if you so choose. And if you do not, well, if you choose not to have a trial by jury, then your case will come before the court or before the judge in one of 3 ways. One way it can come before the judge is by way of a trial without a jury. It will be what we call a bench trial. That is a trial by judge only. The judge will listen to the evidence, listen to the arguments, and the judge will decide to find you not guilty or guilty. Another way your case can come before the judge is by way of an agreed plea bargain. A plea bargain is an agreement that you work out with the state to settle your case. An agreed plea bargain means that you and the state have reached an agreement as to the punishment on your case, and your case will come before the judge. And the judge could either accept or reject the plea bargain agreement. If the judge accepts the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case because you think that maybe you've been wrongfully convicted or the court has committed an error by convicting you, then you would have to get permission from the judge or from the court that convicted you or that followed the plea bargain. And if the judge gives you permission, then your case will go to the Ninth Court of Appeals, which is located right above us. They will review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. Now, they can either grant or deny your appeal. If they grant your appeal, then they can find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. You will have to file what is called a pro se petition for discretionary review. Petition for this pro se means without the assistance of a lawyer. You'll be doing it on your own. Petition for discretionary review basically means that you'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not this court committed an error by convicting you, whether or not you were wrongfully convicted, or whether or not the Court of Appeals should have granted your appeal. Then they could either grant or deny the petition. If they grant the petition, then they can simply find you not guilty, or they can send the case back down to this court or send it to the Ninth Court of Appeals, order this court to give you a whole new trial. Or if they deny your appeal or your pro se petition, then at that point, your conviction will stand. You also have a right to have what is called, the other way your case can come before the court is by way of an unagreed plea bargain agreement. It's different from an agreed plea bargain agreement. Unagreed just simply means you and the state have not been able to reach an agreement to settle your case. And you want the judge or the court to decide what your punishment is. And so with the unagreed plea bargain agreement, the case comes before the judge, and the judge will set the punishment in your case. Okay. Now, you don't know beforehand what the punishment is going to be, but the punishment will be within the punishment range of the offense. You also have a right to have witnesses to come to court to testify either for you or against you. That's what witnesses do. And if you're represented by an attorney, if you're representing yourself, they can be asked questions while they're testifying. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses to come to court. And if you waive or give up your right to have witnesses to come to court and testify, that simply means that you will not be calling witnesses to testify in your case. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in the case that they have brought against you. You have a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your case. The state of Texas, the government, district attorney's office cannot force you to testify against yourself in your case because you have a Fifth Amendment right against self-incrimination. Now, you have a right to waive or give up your Fifth Amendment right against self-incrimination. And if you do so, that just simply means that you will be testifying in your case. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence or discover the evidence that the state has against you or the state will be using against you. That is, you have a right to see the documents, witness statements, your statement, videos, hear audio recordings. You have a right to see photos. You have a right to have access to the instruments that they may be using, test results, whatever evidence that they have that they'll be using against you, you have a right to have what is called discovery. You have a right to have access to see the evidence. If you're represented by an attorney, your attorney will have access to that evidence. Now, everybody that's here for arraignment this morning, you're here because one, you've been arrested and you're out of jail, either on a cash bond, which means you paid the full amount of the bond to get out of jail, or you're here on a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail, or you're here on a PR or a personal recognizance bond, which means that you was released under your personal recognizance. You did not have to pay any money to get out of jail. You did promise to appear in court. Now, every day that you spent in jail, that time can be used towards your punishment. So, for example, if you enter a plea of guilty or no contest to your charge, and let's say you spent 5 days in jail, and the state is offering that you serve 5 days in jail, that simply means that you will not have to serve any more time in jail. Why? Because the 5 days that you spent in jail will be given to you as credit for time served, time that you've already served, so you won't have to spend any more time in jail. If the state is offering 7 days in jail and you spend 5 days in jail, that simply means you will only have to serve 2 more days in jail, because the 5 days that you have spent will be credited toward you. So we'll take 5 from the 7 and that leaves 2. Every day that you spent in jail can also be used as credit toward your fine and court costs. You receive $100 per day that will go toward your fine and your court costs. So if the state is offering you fine and court costs of $500, you serve 5 days in jail, that means you won't have to pay any money. Why? Because the time that you spent in jail has already paid it off. Therefore, the court costs and fine will be taxed and retired. If the state is offering fine and court costs of $700 and you spend 5 days in jail, that means that you'll be required to pay $200, because the $500 will go toward this, be subtracted from the 7, that leaves $200. And you will have to pay that on the day of your plea. However, if you cannot pay it on the day of your plea, the day that you plead guilty, no contest, then we can put you on a payment plan. That is, we can require that you pay it off in monthly installments. And if you cannot pay it off in monthly installments, then we can convert your fine and court costs to community service. And by converting it to community service, every 1 hour of community service that you perform at a nonprofit organization, $12.50 will go toward your fine and court costs. So, for example, if you perform 8 hours of community service, that will be $100 that will go toward your fine and court costs. So an example that I previously gave, if a person has $700 of fine and court costs, they serve 5 days in jail, 500 will be taken from the 700, and so that leaves 200. And that just simply means you have to perform 16 hours of community service, which is 2 8-hour days. Now, Jefferson County has a program that is called pretrial diversion. And with the pretrial diversion program, that is a program for first-time offenders. If you haven't been in trouble before, your case can be dismissed and it can be wiped off, erased, or deleted from your criminal record. And the way the program works is as follows. You have to get an attorney to help you with the application. It cannot be an offense for unlawfully carrying a weapon or resisting arrest. And it has to be your first offense, so you can't have a criminal history. And as I mentioned earlier, you get into the program, the case is dismissed, you complete the program, you can get it expunged, which means erased, deleted, or wiped off from your criminal history. If you're a veteran of any one of the branches of the United States military, Jefferson County has a program, the DA's office that is, has a program that is called Veterans Court. It is for veterans only. And what the Veterans Court program is similar to the pretrial diversion program in that once you are accepted into the program and complete the program, your case is dismissed. And you can get what is called a non-disclosure, as I mentioned earlier. Non-disclosure, they cannot disclose that fact to the general public. Now, the only criteria for getting accepted or being eligible for the veterans program, you have to be a veteran of any one of the branches of the United States military. Jefferson County, this court also has a program that is called pretrial diversion. With the pretrial diversion program, we have partnerships with people. We have partnerships with various agencies in our community. One of the partnerships that we have in our community is with Spindletop, the young people that I mentioned to you earlier. They're going to come to you. They're from Spindletop, and they're going to come to you in a few minutes and tell you about the Spindletop program that they have to offer. With that Spindletop program, you don't have to be insane or incompetent to participate in the program. You can suffer from any mental illness that you may have. They have the ability, the facilities, the expertise to treat a whole host of mental illnesses that a person may have. They're going to come to you and talk to you about that program. One of the things that they're going to do, they can do what is called a private interview. We could do it here in our conference room, or you can do it at their facility, or they may be able to do a telephone interview with you, depending on how your comfort level. The other thing is with Spindletop, they can do an assessment and they can develop a treatment plan, either outpatient or inpatient, to deal with whatever mental health illnesses or problems that you may have. The other thing Spindletop have, they have a program that is called ATAR, stands for Addiction Treatment and Recovery. Along with ATAR program, our local Drug and Alcohol Council has a program that is called OZAR. OZAR stands for Outreach, Screening, and Recovery. And with those programs, what happens, they will be able to do a screening, an assessment, and they can develop treatment plans. You can be referred for either outpatient or inpatient treatment. If you are unemployed, looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in one of the areas that you select, they will assist you at getting a job in the area that you trained in. Now, if you have not graduated from high school, well, CIC has a GED program for all those individuals who like to get their graduate equivalency diploma. Now, all of these programs that I just mentioned are under the umbrella of what we call the CSI program from this court that I started in March of 2017, within 100 days of taking office. The CSI program stands for Community Safety Initiative. With the Community Safety Initiative, it is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so how do we address it? We address it through the CSI program. And with the CSI program, The program is a program that's free. It does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. We believe that if we address the problem, then we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so therefore they will not commit crime. And so in this court, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference of the lives of the individuals that come before this court. We also trying to make it, if we make a difference in their lives, we're going to make a difference in the lives of the people that they're around in their home, and we're going to make a difference in the community in which we live. And so with all of these programs, as I said, we don't have court as usual, we have unusual court. And if you're interested in any one of these programs, we have some brochures and we have additional information that we can give to you to assist you so that you can participate in the program. And as I mentioned, the programs are free. The other thing I should mention is that all of these programs that I just mentioned can be used as community service. So that is, while you are being trained for a job, or you're getting your GED, or you're in mental health treatment, or you're in drug and alcohol treatment, the recovery program, then every hour that you spend in that program, $12.50 will go toward your community service, or one hour will go toward the community service as well. So you're doing one thing, but you're getting credit for three things. You're in the CSI program, that's one thing. You're getting credit for community service, and you're paying your fine and court costs, $12.50 that will go toward your fine and court costs. And so, as I mentioned earlier, if you're interested in the program, just let us know, and we'll be happy to assist you with the program. Now, the young people that I pointed out to you earlier, Deputy Hinton and Gabby, they're from Spindletop. They're going to come to you right now and tell you more about what Spindletop has to offer. At this time, Gabby and Deputy Hinton. You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here with the sheriff's office. And this is my coworker, Gabby. Now, Gabby is a qualified mental health professional. The reason we are both here this morning in this courtroom is because the judge cares about every single person who comes before the bench. What the judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources that help you in your particular situation.
So meaning like mental health, reading, it can be as common as anxiety. Being in this court doesn't help anxiety in any way. But we mean anxiety, symptoms of depression, if you're maybe just laying in bed a lot or just feeling down. This situation isn't ideal, and we do good for that for them. We are not experts in your own situation, but we just want to have an insight to do support. It can be utilized, and I just need somebody to do for it. That's what we do.
It's your first time to be here, maybe it is your 10th time to be here. There's still hope. What we're offering you here today is a chance to change your life, but it's up to you. It's got choices. And Gabby's going to show you how you can do that and how you can share that need with us, and you can best figure out how to serve you in a particular way, in a very private way.
So this right here serves as a hit consent. So you made in the doctor's office that say, hey, your information is protected, no one sees this. This is the same way. The only people who are going to see this is me, not the court, not anybody else, but just me and him. So I'm going to be the one who's going to be contacting you. You're going to get it's going to be a regular cell phone number with our work phone numbers, and so that can receive calls and texts. And so up here, you're gonna check either call or text, whichever one you're comfortable with. This just allows us to contact you once. If you want to keep in contact with us, we'll more than welcome to be there for you. But if you just want to be contacted once in a matter of two, then that's. We're not a robotic type of thing. We're gonna be named, texting others that are calling you. It's just important that you check one of these, and also it says what type of general resources you need. If you just need support, if you would like to talk to us, anything like that, we need you to share that right there. If it's mental health, if it's work, if it's food, clothing, something, if you need anything, please put that right there. And if you do want to talk to us today, sit back, we can step back in the back. You can check yes down here. And if you want to share something, or you're just really anxious, or if you already talk.
We're not here to embarrass anyone, we're here to work with you very privately and look around. We're not here to prolong you staying here or being a part of the work. We want to make this as easy as possible for you. And before you leave here today, I'll get this flyer. On the back of it, it tells you a little bit about the advantages of the core program. And on the front, also has a phone number on there, should you find yourself in an unsafe place, then you can call that number. I'll get that out here. Shortly, the court is going to go into recess, and when it does, we will be out visiting with y'all. We'll pick up the phone, and I'll hand this out to you, and we'll be able to answer any questions you may have at that time.
Thank you.
Thank you, Gabby and
Thank you.
Deputy Henry.
Thank you, Your Honor.
Now, ladies and gentlemen, the paperwork that you have, we have our court personnel who will be happy to assist anyone with filling out that paperwork. It's going to take a few minutes for us to pick up the paperwork and go through the paperwork, make sure that everything is filled out correctly. And then we're going to call you up before the bench one at a time. There's a mark on the floor before the bench, looks like a little X. You can stand there. And for those of you who need to use the restrooms, there are two restrooms right outside the courtroom to my right. The men's restroom is next to in front of county court at law number 3. And the female restroom is on the other side of the hall in front of 172nd District Court. So what we're going to do at this time, we're going to go into recess. Now, if you need to use the restroom, you can use the restrooms. Please do not leave the courthouse, because if you leave the courthouse and if we call your name, you're not here, then your bond can be forfeited. If your bond is forfeited, a warrant will be issued for your arrest, and you will be arrested and placed in the Jefferson County Jail. So at this time, the court is going to be in recess, and we have our court personnel. You just raise your hands if you need any assistance. Should be happy, or they'll be happy to help you with your paperwork. At this time, the court will be in recess.